This is a sick and twisted case that is sadly getting worse with each update.
The victim is a 2-year-old juvenile.
Video there per the Asbury Park Press. This babysitter is accused of sexually assaulting a toddler, recording the footage on her phone and allegedly laughing as she did it. Now, we are actually hearing what may be her side of the story. Victoria Cranmer sobbed in court as the judge made a major decision in her case. What her defense attorney had to say about what happened inside a bathroom as she babysat a 2-year-old boy. We're on the case presented by Law&Crime. I'm Chris Stewart. What in the world could the defense for Victoria Cranmer actually be? A babysitter who is accused of the kind of crime that when you hear about it, frankly, when I talk about it, it just makes your body shake. Victoria Cranmer is accused of sexually abusing a boy who she was babysitting, and is believed that the victim in this case is just 2 years old, a toddler. And she's also accused of recording that alleged crime. And that's sick. Even more sick, she was allegedly laughing in the video. Now, we'll talk a little bit here in a moment about what her defense has to say about all of this, what they said in court, and why they say that everything that we've heard, all the allegations over the past several days, that it's all been blown out of proportion.
One of those videos was a 14-second video clip taken while inside the bathroom at the child's residence. The video showed the defendant naked from at least the waist down, sitting on the toilet, while the 2-year-old juvenile stood next to the defendant.
Cranmer made a court appearance this week in Ocean County, New Jersey. This is video per the Asbury Park Press. This hearing was to determine if Cranmer would be given the chance to be free as this case moves through the legal system. Now, her defense attorney, a public defender, addressed the court, tried to give some context from Cranmer's side about what actually happened, and we'll share with you what that attorney had to say here in just a moment. But before we get to that part of the story and what we learned in court during this hearing, I do want to break down some new details that we have just released in court documents related to this case. So if you are just catching this story for the first time, here is the accused abuser, a babysitter named Victoria Cranmer. She's 25 years old, and the quick timeline of this case is that on May 20th, police in Little Egg Harbor, New Jersey, were alerted to a horrific video allegedly found on Snapchat. There's a woman who in court documents is identified as Miss P, and Miss P reportedly finds this video. Authorities say Cranmer lived with Miss P and her child for roughly 3 months because she apparently needed a place to stay. Now, during the course of that stay, Miss P reportedly buys Cranmer an iPhone. It was a birthday present in April. Cranmer also, it's important to know, did babysit Miss P's child, according to those court records. Now, the relationship and the housing situation apparently blew up after Miss P allegedly makes this terrible discovery on the phone. Now, according to court records, Cranmer has alleged mental health issues. Things in the house apparently got so bad after 3 months that Miss P tells Cranmer that she needs to get out. But not only just leave the house, she can't keep that phone that was given as a birthday gift. So Cranmer leaves that behind, turns it over to Miss P, according to these court records. All of this taking place about 2 weeks before police start investigating on May 20th. Now, Cranmer returns this cell phone, and on that cell phone would allegedly be the kind of video that you cannot fathom or unsee. That video was found in Cranmer's Snapchat memories, according to prosecutors. It is a 14-second video showing Cranmer allegedly sexually abusing a child so young that they were still in diapers. Now, according to the documents that were obtained by several media outlets, including the Asbury Park Press, and I do need to warn you that these specifics, they are just so difficult to even read for this story. It's just such a terrible, terrible case. The video allegedly shows that child touching the 25-year-old Cranmer as she sat on a toilet, and this child believed to be just 2. This is what the prosecutor said during the court hearing per the Asbury Park Press.
The victim can be seen touching the defendant's area, specifically the defendant's area. During the video, the defendant can be heard laughing at the victim and telling the victim that she's pulling on the defendant's.
So Miss P allegedly knew that it was Cranmer in this video, not only because she could tell what bathroom she was in, but she also recognized tattoos on Cranmer's body. Now, when you look at Cranmer in social media images, you can see that she has several tattoos. Specifically, documents allege there is one that's very unique. It's of female breasts. And then there are others showing a lightning bolt and a mushroom. And apparently Miss P saw that and knew exactly who was in that video. And you could think that that is very important evidence as this case goes forward. Now, the victim's mom has been identified in the court records as Miss H. And this is really sad. She said that she could tell something was off with her toddler after he spent time with Victoria Cranmer. She said that her son stopped liking the bathtub. And prosecutors allege that Cranmer allegedly bathes with this boy, according to those court records obtained by Patch. Now, the 14-second video was allegedly taken on May 6th. Then you have this investigation starting on May 20th, once this video is discovered. Then you have the arrest of Victoria Cranmer. That didn't happen until July 8th. Police say they discovered additional videos on her phone, but it is unclear at this point what those videos show, but it's been alleged that it is her and that 2-year-old male victim in this story. Guys, real quick, running a business is tough enough, but why make it harder doing things manually or relying on dozens of apps that don't talk to each other? That is where our sponsor, Odoo, comes in. Odoo is an all-in-one business management platform with a full suite of integrated apps that seamlessly connect all your operations from sales and accounting to manufacturing and even shipping. Odoo can automatically generate professional, sleek-looking sales orders, invoices, and vendor bills, and it can automatically assign sales teams, send email updates through each sales stage, and even use AI to pull reports that help with your decision-making. For manufacturing, their apps can sync inventory with real-time production and purchase updates so you never run out of stock. And when it comes time for accounting, that is also fully automated. Odoo can create invoices, track expenses, and even summarize data with AI to save you hundreds of hours. And the best part, you can choose your apps and even build custom workflows so it is all fully tailored to your business's needs. Take your business to the next level by consulting with an Odoo expert today for free at odoo.com/OTC. Now, Cranmer right now is facing charges of second-degree assault on a child, endangering the welfare of a child, manufacturing child sexual abuse material, and possession of child sexual abuse material. Cranmer made this court appearance for a detention hearing in Ocean County Court. Since her arrest, she has been held without bail. In court, as we saw her for the first time, she looked emotional as the allegations were read aloud. She appeared virtually from jail. The Asbury Park Press laid out what Cranmer's defense attorney said, and these were comments she made in hopes of getting her client out of jail. So here is what that defense attorney said per the Asbury Park Press, trying to, it seems, downplay what she's accused of. Quote, anyone who has spent time caring for young children understands that children often have little appreciation for personal space or privacy. Young children routinely follow parents or caregivers in the bathrooms, touch things, ask questions, are curious, and fail to recognize ordinary social boundaries. Again, this is what public defender Marissa Kohner told the court. She also reportedly said this about her client allegedly recording that incident. Quote, children often engage in funny, spontaneous, or strange behavior that adults record because the moment is memorable and humorous. End quote. The video has been blown out of proportion, Kohner said. Now, in response to that, this is what the judge said. Quote, the word to describe it is bizarre. That the child follow Cranmer into the bathroom was not the strange part, according to the judge. What was bizarre is that Cranmer did nothing to stop the toddler from touching her private area, and she laughed, giggled, and recorded video of it while it was taking place. I find it to be troubling there wasn't any attempt to stop the child from touching her in the private area. Now, Cranmer, according to the newspaper, was sobbing when the judge made the decision that she will remain in jail going forward as her case is pending. Cranmer, according to online court records, is next slated to make an appearance in court on August 3rd. If found guilty, Cranmer is facing a very steep prison sentence. On one hand, she would have to register as a sex offender for life, according to New Jersey law, but she's also facing the possibility of that sex assault charge and the manufacturing CSAM. Those are both charges that carry 5 to 10-year prison terms. Her other charges would also carry up to 5-year prison terms, per the Asbury Park Press. Joining us now to talk more about this is criminal defense attorney Eric Faddis, also a former sex crimes prosecutor. So great person to have perspective on what's a story getting a lot of attention because the allegations, it And it makes you shake when you just think about how disturbing all of this is, Eric. But you have this bond hearing, and reportedly the defense attorney for Victoria Cranmer kind of trying to argue away the allegations, which seem very bad with how they're written in court documents, saying that, this was just, almost saying everything's been blown out of proportion. What do you make of that argument and the situation that you're in as a defense attorney in this type of hearing?
Sure, Chris. Well, in looking at the charges, a central element of all of them, I believe, is that there was something sexual in nature going on. And really, when we hear the defense attorney and how they're presenting their argument at the bail hearing, they're basically saying, hey, there may have been physical contact. There is a video. They're acknowledging all of that. But they're saying that this contact was not sexual in nature. In my reading of it, it appears they're kind of alleging that this 2-year-old was the one who was kind of initiating the contact, was curious, did not really understand boundaries at that point. And that element, whether there was something sexual going is really critical to this case.
And you have the judge who made the decision that Victoria Cranmer is going to continue to be held without bond. And he points out in court, from what he understands, that there really wasn't an effort to stop it. I just think of, we'll see how this case plays out going forward. But like when you have a judge kind of looking at it in that moment, and I don't know if he specifically saw it or if he's just reading off of the allegations, what do you make of the judge kind of looking at this and having that type of read and then saying that publicly in court?
Yeah, the judge is in a bail hearing making a determination in part on whether the defendant is a danger to the community. So he's reviewing all the allegations. He may have reviewed this video itself, and his opinion on it probably matters because this is not just some guy off the street. This is a learned jurist who has presumably seen cases like this before, and so for him to be kind of taken aback to say, hey, it didn't appear as if the defendant was trying to discontinue any of this conduct, I think carries significant weight. And if that was the judge's reaction, how might a jury react?
Right. And you have to be wondering that if you're this public defender, and we'll see if she gets private counsel going forward. Because this isn't a trial, but you have a judge making a decision just based off of it straight up that he just doesn't feel like there was an effort in stopping it. And that certainly kind of reiterates the troubling concerns in the PC. As a defense attorney, are you kind of shoehorned into that defense now that, hey, all of this is being really blown out of proportion, where if she were to go to trial a year from now, is what is said in a bond hearing something that then has to continue on into the trial?
It is not something typically by which the defendant would be bound later on. If your attorney makes some argument early in the case at a different hearing, that doesn't necessarily mean you're sort of pigeonholed into that particular defense. For example, at the jury trial phase, if we get that far, the defense might argue that this wasn't her in that video, or they can't prove that it was her. And that is, a different argument than saying any contact was not sexual. I think that those potential arguments and defenses are still on the table, even though they chose to ride a particular horse during this bail hearing.
And going from here, if you're a prosecutor, so let's flip to the other side on this. You have this reportedly a 14-second video that, it's just difficult to even describe, involving allegedly a 2-year-old and then Victoria Cranmer. And there's something that reaches the level of what they consider to be sexual assault, allegedly. What more evidence would you need other than just pressing play on this video if this were to go to trial?
The video is going to speak volumes. It's going to perhaps capture the defendant's reaction to what's going on. How might she be perceiving this? What is her interpretation of whatever interaction is depicted on that video? That's important. Also, conversations with the defendant that the mother of this child may have had. I understand the defendant was staying with a friend whose child she was also babysitting. It was a different child. But you would want to at least buttress your case from prosecutorial perspective. You have the video that might be super helpful, but some additional witness statements in terms of, perhaps this defendant might not have been sort of blasé about, sexual interactions or boundaries or things like that. If you had such evidence in witness testimony, that would only corroborate what you're saying this video depicts. So the video is critical, but certainly having more information could not hurt. And it's a high bar in a sex case, to get a jury to convict somebody and brand somebody with that scarlet letter for the rest of their life of a sex crimes conviction. Some folks think that that's in essence a higher burden than with other crimes, although under the law it shouldn't be.
Yeah, it seems like the woman who is identified as Miss P in the document, so that's the friend who she was allegedly living with. She says that she kind of recognizes the bathroom where this video took place, and then there's some unique tattoos that Cranmer apparently has that also tied her to that video. I think of the victim in this case, we're talking about someone who, according to these court documents, is believed to be just 2 years old. It is just, it's tough. And I know you prosecuted, a lot of difficult cases with details, I'm sure, that are like this. But a 2-year-old can't go on the stand and accuse someone of something happening. In the court record or in the reports based off the records that we're reading, like the mom realized that the boy no longer wanted to use the bath, which is really sad. But how does that get entered in? And then how does that 2-year-old, as an alleged victim in this case, how do you build that credibility around someone who can't speak?
It is a significant impediment, I think, for the prosecution. And I think it opens up possible challenges on the defense side. Defense is going to say, hey, they can't call this 2-year-old as a witness. We don't know what was going on in the 2-year-old's head. We don't know what the 2-year-old, how he may have been perceiving this interaction, the actions that he may have chose to initiate, according to defense, of course. And I think that it opens up a lot of speculation about what more could have been going on cognitively and psychologically and emotionally during this interaction. I think it sort of invites the defense to ask the jury to speculate about those things, even though technically jury is not supposed to speculate in deliberations, but it can be sort of suggested in an artful way by defense of the trial phase.
Right, 100%. How often do these cases, she's facing CSAM charges. I feel like a lot of these end in plea deals. How likely is it, just based off what we know at this point, that this is something that you might actually have a strong argument? I know it's early, but that the defense would feel confident of, hey, you're looking at 30 potentially plus years in prison and a lifetime sex offender registry. How does that factor into kind of the strategy you have going forward?
Chris, it's no secret that if a person is convicted of SA on a child, a judge is liable to drop the hammer on that individual and just sentence them to potentially years, if not decades, in prison. So the exposure is great, and the prosecutorial leverage is very significant too. So from the defense calculus, you kind of have to do these analyses where you're like, hey, what's the chance that we're going to win at trial? And what's our potential exposure if we lose? Compare that to what might be a sure thing in terms of a plea deal. There could be a plea deal for a person if this individual does not have significant criminal history, and if there isn't some sort of pattern of similar conduct. It wouldn't be uncommon for the prosecutor to say, hey, this is your first time, it's extremely egregious, and we're going to do something firm and assertive, but not really throw the book at you. And that might be an attractive option to defense when you have allegations that just by their very nature are so shocking and inflammatory.
And it seems like this 14-second video, you talk about a smoking gun in a case like this. For a judge to even look at it and call it, I think the word he used was bizarre, but then to say, clearly in his mind that there was really no effort in stopping the interaction of whatever it shows. I guess what would the chances be for the defense to get that thrown out? What goes into that? Because we do see in some of these cases where from the public, we look at a piece of evidence and we're like, how do you go ahead to trial without having this? It changes the way you look at something. But there are good defense attorneys out there that can get evidence taken out of what could be shown at trial. Like, what are you looking at if you're a defense attorney and you have this video and you say, hey, with this video, we may be in trouble, but without it, I have a chance to get my client off?
Oh, right. I think from the defense perspective, you want to explore how the government came into possession of this video and did they do so constitutionally? Because, Chris, as you know, if there is a constitutional violation in procuring evidence, even if it's really important evidence, sometimes that can lead to suppression of that evidence at trial. The jury never sees it. My understanding in this case, however, is that the defendant had the phone, it was hers, but when she parted ways with her roommate who bought her the phone, she left the phone with the roommate. So when you abandon property, you really don't have a reasonable expectation of privacy in that property. And my understanding is the roommate then went to police after seeing the video and gave police the phone, consented to them searching it. So under those circumstances, I don't think there's a Fourth Amendment violation. I don't think there's another constitutional violation that's going to preclude admission of this, what appears to be a very damning video.
Yeah, does that count too for the apps on the phone? So apparently it was in like the Snapchat memories. She gives, I guess the phone was bought for her as a gift. Phone is given back after she moves out of the house. And then Miss P in court records goes into the phone, finds this video in the Snapchat memories, and then alerts the authorities. Does that also include, like, you get someone's phone, it's their username, there's no protection that says that it's a violation of privacy to actually go into that person's, the apps on the phone, something like Snapchat?
Sure. So, for example, if the defendant had retained this phone and the cops came by and they were like, give me that, and they just started looking through it, that might be a Fourth Amendment violation resulting in suppression. But here, my understanding is what police did is they learned of this potentially contraband video on the phone, and then from there devised a search warrant for these apps. Police can send search warrants and what are called production of records requests to apps like Snapchat, Instagram, YouTube, you name it. And the police did that because they said, hey, we know there's some criminal stuff going on here. We need to see if there's more criminal stuff going on. Judge, give us a warrant to look at the entirety of the app. And that's what the police did. That's how they came into possession of this allegedly criminal material. And so I think that's pretty by the book.
Yeah, and it seems like for her history as well. I'm just thinking of, because in all of these, I'm not trying to give the audience like sympathy to this defendant, but just more like, we've obviously seen this story over the past couple of days. Like, how do you even defend a case like this? It's alleged that she has some sort of mental health history, potentially a traumatic childhood, just based off of what I've seen on social media. For a defense attorney, like, how does that factor into what you could put together in hopes of a positive outcome when it does seem the evidence is so strong on the prosecution side at this point?
Totally. This case is ripe for what's called a mitigation packet. So that's when defense really compiles a bunch of information that's favorable to the client. So what they'll talk about in part is that, hey, Mr. and Mrs. Prosecutor, it's going to be pretty difficult to prove that this was for sure sexual contact. How can you rule out the fact that this kid was just being curious and exploring whatever? And then, but even though there is some risk there, this is all the background of my client. These are the things she has been through. She's had to contend with things that other folks have not had to contend with. That has made things more difficult for her. If there is any prior abuse, and I have no idea if there is, but if there were, a defense attorney would cite to that, would say, hey, look, in fact, my client has been a previous victim of this. And we look at studies that show previous victims of that kind of thing are more likely to engage in it, unfortunately, than folks who have not been previously victimized in that way. So you compile that background information, that historical record of your client and what they have been through to try to garner sympathy to try to convince the prosecutor this case is mitigated and you should take a more lenient approach. That would be a common tactic for defense in terms of mitigation package.
Apparently, they found some other videos on this phone. It's unclear what those show. She's babysat, for Miss P's child, Miss H, just the names that are in the court records. That's the alleged victim, the 2-year-old boy. How do you, as a prosecutor, kind of factor in a timeline of this case going forward, where there is the possibility that potentially there are more victims and law enforcement has to continue to investigate? I mean, you never know. But at the same time, you certainly have a lot of strong evidence, it seems, at this point. And I know it's in the early stages. We're talking months, maybe a year down the line until you see some sort of conviction or verdict. But how do you factor in ongoing investigations as you're trying to put together a case?
You know, that is so front of mind, Chris, for a special victims unit prosecutor. Is this an isolated event, or could this be a pattern? You look into the digital footprint, you interview everybody under the sun that was around this person, everybody for whom she babysat. I mean, that's step one. My understanding in reading some of the reports is there might be an allegation that she also had a bath with this kid or with a different kid. It's a bit unclear. That tells me that this may not be just a one-time, oops, I didn't know what was going on, it wasn't sexual, whatever. That tells me that there is a pattern, at least, of improper boundaries, and when that comes to children, gosh, the alarm bells signal, and you've got to really scour the earth to determine, hey, has this happened to somebody else? And if so, do we need to add charges?
Yeah, it's just such an awful story. And we're seeing kind of her side of the story, presenting that to the audience. People can make what they want. I mean, clearly this video, and I don't think it's something that anybody wants to look at, but clearly this video is at the center of this case. We'll see what happens next. Eric Faddis, Mile High Lion, criminal defense attorney from Denver, Colorado. Thank you as always for taking the time to be with us on Law&Crime. We appreciate it.
Always a pleasure, Chris. Thank you.
That will do it for On the Case, presented by Law&Crime. Subscribe to us on YouTube and Spotify, and we are also streaming on Peacock. I'm Chris Stewart. We'll see you next time.